A man has been ordered to pay just over 3 million rand in spousal and child maintenance arrears. The Supreme Court of Appeal has clarified that debt incurred for the non-payment of spousal and child support can still be claimed 30 years after it was made an order of the court. It's dismissed an application by the man who failed to pay maintenance for his former wife and 2 children, as it argued that it was unfair to enforce the claim, he argued, nearly 30 years after he got divorced. Let's get you some perspective on the story. We're joined in studio by attorney Thato Mahapa. He's going to explain to us the importance of this development. Thato, welcome to studio. It's great to have you here.
Thank you.
And it's an incredible victory for a particular segment of society, because we know that maintenance claims by their nature are very gendered.
Indeed, very gendered. The beneficiaries of maintenance claims in most instances is women and children.
Right.
And not just women, but the most vulnerable ones financially. So it's always a exercise of abuse of power by the one person to not pay maintenance claims, barring any circumstances, because you have a legislative provision that enables you, if you don't have the means, to go to court and say, look, I don't have the money to pay, can we vary the order, can we suspend the provisions and so forth. So a person in the position of this gentleman who was appealing has always had avenues to be able to go to court and say, I can't afford to pay for the following reasons, and this is why I want. So he sat and did nothing.
So his ex-wife lodged this claim, according to the information that I have here, 25 years after the divorce.
Indeed.
On the basis of the time that had lapsed, what did this man argue to try and escape paying this, the maintenance he should have been paying all along?
So in general terms, you have what we call prescription of claims. Where a person has a claim against somebody else, they generally have a 3-year period within which to lodge the claim in the form of issuing summons. So there's different periods that apply to different types of claims, but generally where there isn't any specific provision, you have a 3-year time period in terms of what we call the Prescription Act. Now, the gentleman argued that because this was a maintenance order, it wasn't a judgment of court, it was coming from a settlement agreement and a divorce, it did not have the effect of a judgment debt. Judgment debts have a 30-year prescription period. So his argument is that, no, she had a claim, sure, but she could have come to court and argued it within the 3 years. After the 3 years, it falls away. So the court looked at it and said, well, effectively, what you're saying is that the very same vulnerable people have to come back to court every 3 years to come and argue and keep on coming every 3 years. Why don't you just accept the responsibility to actually pay and discharge your obligation? You're the one with the obligation in the first place. But in any event, it saw through the smoke screen.
And of course, if the court had decided around that 3-year period, it would have set a precedent for other maintenance cases.
It would have had consequences.
A really bad precedent. Yeah.
Indeed, you have people who want to claim area maintenance, and they're frustrated by sometimes, maintenance costs can be backlogged, especially with COVID having happened over the past 2 years. If you go to any maintenance court, there is always a ton of people waiting just to get assistance. So the machinery moves as fast as it can. In some instances, it moves too slow. So to be able to get a judgment and then be subjected to this 3-year time period would have just frustrated the most vulnerable people. So it makes perfect sense that the court chose to apply what we call a purposive interpretation. And it said, let's look at the purpose that the Maintenance Act was provided for in order to come to a conclusion as to what would be the correct interpretation. So the argument that you had 3 years works in different instances where there's a claim that has not been adjudicated, that is not final. In this case, a maintenance order is an order of the court. Whether it came from a settlement agreement, because effectively when you make a settlement agreement, the last prayer in a settlement agreement is, please make this agreement an order of the court. So it changes its status from being just a private treaty between you and me and makes it an order of court.
Okay, my question is, do you reckon this is going to open the floodgates now? in terms of people who have potentially, we called it a backlog of claims, but it's not actually a backlog. But, you know, if I haven't been paying maintenance for the past 25 to 30 years, and there's been no attempts made by my spouse to get that maintenance from me, do you reckon this is going to open the floodgates for that kind of case now?
Indeed, for as long as there's an existing order. I actually have one such similar matter where there's an order that was made in 2008. And only recently we got an order for collection of area maintenance up to 1.7 million. You know, it's not something that's gone to the Supreme Court, but there's a provision in terms of Section 27 of the Maintenance Act where you can go and collect area maintenance if there's an existing order. So the claim that the respondent had, the defense that the respondent had in this matter is exactly the corollary of what we have in that matter.
I mean, there are hundreds of thousands, if not more, cases like this in the country.
Absolutely.
We need to look at one community and we'll know a number of people who are owed years and years worth of maintenance. The question, though, is, do these people have the legal means to go about getting that maintenance paid to them and to their children?
I think the question that you're asking taps into a bigger set of difficult circumstances. One, ordinarily practitioners will tell you that we engage with maintenance officers whose interpretation of the Act is sometimes not the most generous, and it's not consistent court to court. So you find that one will tell you, no, you can't do a Section 27 application ex parte, you must serve it, whilst the Maintenance Act says one thing. So the fact that this comes in a Supreme Court of Appeal judgment and it is widely publicized means that the knowledge gets distributed wider, and the reception that you will then get from maintenance officers will be much better. So a person who is a litigant sits in a better opportunity to know what their rights are and to be able to seek the maintenance court's assistance to enforce those rights. Because the Maintenance Act obliges maintenance officers to assist an applicant, unlike with civil matters where the registrar sits as a neutral person. With Maintenance Act, it obliges a maintenance officer to actually assist you. So if we're being honest, if things were equal, you shouldn't need an attorney to claim for a maintenance claim.
Okay, so as we wrap up our interview, your bit of advice for someone who is sitting in the position that this woman and her two children were in 25 years ago, where they've gotten divorced, they've ended their marriage, there is a maintenance order in place, no money is paid in terms of that maintenance order. What's your advice to that woman who's sitting at home watching? And then secondly, perhaps the advice to the person who should be paying maintenance. You don't have to wait 25 years. Just go ahead and pay the monthly payment.
You don't have to wait 2 weeks. For as long as you have a maintenance order, and in fact, the bottom line is you don't need a maintenance order to take care of your children. You just need to do what's right. But where there's a maintenance order, it is your prerogative to comply with the maintenance order. Where there isn't a maintenance order, it's a different story. You still have an obligation to comply. The person who sits at home with an order that they've not been able to implement, this act tells you, this judgment tells you that it is your right. Go to court, seek the court's assistance to do a calculation of the claim. Make sure that you have your order, you have your supporting documentation. The order will say they must pay into a bank account, and they haven't paid into a bank account. You'll get those bank statements. You know, if you are unsure, go to a maintenance court, and it is the obligation of a maintenance officer to assist you to formulate your claim, to get the documents that you need, and to be able to take your claim forward.
Yeah, and let's hope that, as you say, as widely publicized as the story is, that you get the kind of help that you need. Thato Mahapa is an attorney giving us some perspective. Thank you for coming into studio.
Thank you.
On this incredibly important piece of this decision by the Supreme Court of Appeal. It's clarified essentially that the debt incurred for the non-payment of child and spousal support can still be claimed 30 years after being made an order from the court. Incredibly important story.